Good afternoon, friends, and welcome to Gradeup. Myself, Surajit Bhaduri, is going to take your session right now on Legal Maxim Part 3. So, we are done with Legal Maxim Part 1, Part 2, and today we are going to start with Legal Maxim Part 3. Those of you who have not seen the previous classes or could not attend the previous classes, I would request all of you to just go through that video, share it amongst your friends so that those people who are preparing for CLAT as well as other law entrance examination will have a good idea of what is legal maxims. Okay, so we start with today's class. I guess you guys have started preparing well for your examination right now, because we are into a lockdown we are conducting classes for people who cannot step out of their home but their exams are near. You don't know when this exam will be held. These exams, the CLAT exam or other exam, might get postponed, but we do not have any surety about the same. Henceforth, keeping this in mind, let us prepare ourselves so that you can be in a good position when you sit for that exam. Okay, friends, it's a very, very important exam. I am not scaring you people, but it is also a little difficult exam. So keep that in your mind that CLAT, ALIT, SLAT and other entrance examination is not a class 12 board exam where people score 98 percentage, 99 percentage. This is an exam which is going to test your knowledge. It is going to test your reasoning skills. So to understand or to prepare well for this exam, this class will be very, very important to all of you. Am I clear? So we start with today's class. Legal Maxim Part 3. Let's look into the first legal maxim, and that is known as Mandamus. What is a Mandamus? It's a writ. It's a kind of a writ. I'll tell you what is this Mandamus all about. Before that, let's understand where can you file a writ. You can file a writ petition if your fundamental rights are violated. You can file your writ petition only if your fundamental rights are violated. You can file a writ petition in the Supreme Court under Article 32 and in the High Court under Article 226. Very, very important. Am I clear? So under Article 32, you can file a writ petition before the Supreme Court, and under Article 226, you can file a writ petition before the High Court. Am I clear? That is known as a writ. Now let's see what is Mandamus. A Mandamus is a kind of an order that is issued by superior courts. Which has jurisdiction that commands an inferior court to perform or refrain from performing a particular act. That means a Mandamus is an order from the court to direct a lower authority. Suppose the municipal corporation is not performing its duty which it is duty bound to do under the law. Suppose the municipal corporation is bound to do a particular thing under the law and the municipal corporation is not doing something. So you can go to the High Court, you can go to the Supreme Court and tell the judge that the municipal corporation is duty bound under the law to do a particular act. and the municipal corporation is not doing that particular act, then the judge of the High Court or the Supreme Court might pass a mandamus, might direct the municipal corporation to do a particular act or not to do a particular act. Am I clear? Am I clear, friends? Did you understand? Okay. So mandamus is an order that is issued by a superior court to an inferior court to perform or refrain from performing a particular act which it has an obligation to do under the law. Am I clear? Okay. Am I clear? Okay. Up next. The next important maxim is nemo debet essex judice in propria sua qua. It means no person can be a judge in his own cause. Am I clear? Now let's understand. What does this maxim mean? It means it's a kind of a principle of natural justice. It's one of the principles of natural justice. It simply means that a person cannot be a judge in his own cause. For example, here is a matter. Here is A and B, two companies. There are two companies, okay? A and B. They are fighting a legal battle. They are fighting a legal battle. Now, here is Judge X who is deciding this case. Now, suppose this Judge X has bought 500 shares of company A. Am I clear? Of company A, the judge has 500 shares. Now, the judge might be biased, might be a biased judge. Henceforth, the principle is no person can be a judge in his own cause. No one ought to be a judge in his own cause. For example, here is Mr. X who is alleged to have committed murder. Mr. Y is a judge who is the father of X. He is the father of X. Am I clear? Now, can the father decide on the murder of his own son? Can the father decide whether his son has committed murder or not? What will people say? What will people at large say? They will say that the father did not punish him, did not do this, did not do that. They will raise a lot of eyebrows on the judiciary. That is the reason why it's a principle of law that no person can be a judge in his own cause. Am I clear? Did you understand, friends? Okay. Up next, nemo proprietio pro aliigno deliquoto. It means no one is to be punished for the crime of another. Now, suppose Mr. A has committed a crime. Will his father be punished? Or his son? Or his daughter? No. So, a person who has committed a crime will be punished. Suppose I commit a crime. Will my father be punished? Will my brother be punished? Will my sister be punished? Will my wife be punished? Will my daughter be punished? Will my son be punished? It is only me who will be punished. Am I clear? Am I clear? Am I clear? So, there is no concept of someone else being punished. Am I clear? There is a concept called vicarious liability in law of torts. The concept of vicarious liability is not applicable in criminal law. The concept of vicarious liability is not applicable in criminal law. Am I clear? Am I clear? Did you understand, friends? Up next, nova constituo futuris formam imporne debit non praesitis. It means a new law has to be prospective in nature. It cannot be retrospective in its operation. Okay? Okay? Now, suppose a law is made in 1956. Suppose a law is made in 1956 which says that a Hindu cannot have more than one wife. Am I clear? So in 1956, the law says that a Hindu cannot have more than one wife. It cannot. Suppose a person who has married in 1948, he has 3 wives. Can he be held liable for it? Can he be punished? No. But a person in 1959, if he has 2 wives, he will be punished. Am I clear? Am I clear? Am I clear, friends? So a law that is made by the parliament, has to be prospective in nature. It cannot be retrospectively applied. Am I clear? Okay. Just give me a thumbs up if you have understood it. Okay. So a new law, for example, a tax law cannot levy tax on a previous income. It can levy tax on future income. Am I clear? Okay, fantastic. Now let's come to the next important maxim, obiter dicta. Now, obiter dicta means some remarks of a judge which is not necessary to reaching a decision. Suppose while argument, now before a court there are a lot of arguments that happen inside the court. Okay, so when a matter is heard in the court, both sides argue a lot of things in the court. Now there are certain remarks that are made by the judge which are not necessary for reaching a particular decision. Those are just comments. Those are just comments or illustrations or thoughts. That is known as obiter dicta. Am I clear? Most of these legal maxims are in Latin or in Roman. Okay, so these are all words which are derivation of either Roman law or from Latin. Okay, am I clear, friends? If you have understood, just give me a thumbs up. That's it. And do not forget to like this video. Do not forget to like this video and share this video with your friends. Do not forget to like this video. If you are liking this video, please like the video and share it with your friends. Okay? Obiter dicta means those remarks of a judge which are not necessary to reaching a particular decision. These are something like comments, illustrations or thoughts of the judge. Am I clear? Did you understand this? Friends, it gives us immense pleasure at Gradeup that we have launched a Target Law 2020, a Scoreup course. We have already launched a Target Law 2020, a Scoreup course, which is aimed at providing 100+ live classes, interactive quizzes, practice questions, 12 plus mocks, topic-wise quizzes, PDFs for revision, current affairs and legal knowledge. So those of you who are interested and has not yet enrolled themselves, those of you who have not enrolled themselves, be fast. We have already started with the course. Am I clear? We have already started with the course. Please enroll yourself so that you are well prepared, you stand well prepared, so that you can have a great chance of cracking CLAT and other law entrance examination. Okay. So friends, up next is the CLAT YouTube schedule. Please take a screenshot of the same. Please take a screenshot of the same so that you can attend these free classes. Okay. Am I clear, friends? Up next, per incurium. Per incurium means a wrong judgment. A judgment which is committed, which is written by mistake. Suppose a judge does not take into account a previous judgment which is rendered by the court. Suppose there is a 5-judge bench judgment of 2000. Okay. Now in 2020, a 2-judge bench pronounce a judgment which is contrary to 2000 judgment. Am I clear? Suppose a 5-judge bench has said a particular thing in 2000, in the year 2000. In 2020, a 2-judge bench does not take into account the judgment rendered in the year 2000 and pronounce a separate judgment which is contrary to the 2000 judgment. That means the judge has committed a wrong. That judgment is called per incurium. Am I clear? Am I clear? Am I clear, friends? Judges cannot be punished. No, judges cannot be punished. But the judgment is per incurium, meaning it does not have the force of law. It is committed by mistake. Am I clear? Am I clear? Okay. Okay. Fantastic. Fantastic. Up next, Q facie per alium facet per se. It means he who acts through another act by himself. Now, this is the concept of vicarious liability. Now, suppose I ask my servant to go to the vegetable market and buy some vegetable for me. Now, he goes to the market. He goes to the market to buy some vegetable for my benefit. Who is going to eat those vegetables? It is me. But suppose he goes to the market, while coming back he meets with an accident. Who is liable? I. That is called he who acts by or through another acts for himself. That means if I ask my servant to do a particular act, if I ask my servant to do a particular act and he commits a wrong, he commits an error, the law will think that it is me who has committed that error. The law is going to punish me. Am I clear? Am I clear, friends? Okay. Up next, quid pro quo. Quid pro quo. It means something for something. Now, there is a lot of quid pro quo. There is a lot of quid pro quo saying people are using this word quid pro quo. You must have heard it in TV after former Chief Justice of India, Justice Ranjan Gogoi, was appointed to the Rajya Sabha as a nominated member. He said there are contentions. People are saying just because he gave a judgment in favor of this government in the Babri Masjid demolition case, he has been awarded with this nomination. So quid pro quo means you do something, you do me a favor, I will return you back with a favor. I do a favor to you, you do a favor to me. That is the meaning of quid pro quo. It means something for something. Am I clear? Justice Ranjan Gogoi has retired from the office of the Chief Justice of India. Yes, he is the former Chief Justice of India. Am I clear? Quid pro quo means you give me something, I give you something in return. A favor, a favor. Am I clear? Am I clear, friends? Friends, do like this video and share this video with as many people as you like so that people get some advantage, so that people get some knowledge if they are planning to sit for CLAT and other law entrance examination. Am I clear? Please like the video and share the video with others also. Then next is quo warranto. Quo warranto means by what warrant? By what warrant? Suppose a person has been appointed. Suppose a person has been appointed to a public office. Okay. Now, for example, when does a high court, when does a judge of Supreme Court retires? 65 years. Am I clear? A judge of the Supreme Court retires when he attains the age of 65. Suppose Judge Y is appointed to Supreme Court and his age is 66 years. Can he be appointed? No. If he is appointed, you can file a petition, a writ petition of quo warranto and tell by how is this Judge Y being appointed in the Supreme Court when the retirement age of a judge of the Supreme Court is 65. He is appointed at the age of 66. That means he is above 65. How could he be appointed? Am I clear? Am I clear, friends? Did you understand? What is quo warranto? Quo warranto means if a person is appointed to a public office and if his qualification does not matches with the required qualification, his appointment can be challenged by a petition of writ that is called quo warranto. Am I clear? Am I clear? Did you understand, friends? Did you understand? Okay. Up next is ratio decidendi. About 2 minutes back, 5 minutes back, we studied what is obiter dicta. Obiter dicta is the comment of a judge, is some passing comment of a judge while he comes to a decision. Now, ratio decidendi is the reason, is the rationale behind the decision of a court. Now, this is the operative part of a judgment. Am I clear? So, ratio decidendi is the reason or the rationale behind a judgment. Am I clear? Am I clear? Okay. ratio is the reason or the rationale behind a judgment of a court. It is not a passing comment. It is not just an illustration. Am I clear? Did you understand? This ratio decidendi is the reason why a particular judgment has been rendered by a particular court. Am I clear, friends? Okay. Friends, we have started a Target Law 2020, a Scoreup course. We have started a Target Law 2020, a Scoreup course, which will consist of 100 plus live classes, interactive quizzes, 3000 plus practice question, 12 plus mock test, topic-wise quizzes, PDFs for revision, and full coverage of your current affairs and legal knowledge. Okay, so we have started with this course. Those of you who haven't enrolled themselves, I would ask all of you to enroll yourself to this particular course where we are providing online classes to students. We have already started with the course. Okay, so at 12:30 today we had a class. We understood what are the various types of torts. We studied what is trespass, what is nuisance, what is negligence, what is malicious prosecution, what is defamation. So these are the things that we did study today. Okay, so please make sure that you enroll yourself for this course so that you are not left behind your competitors. Very, very important. It's a tough competition. Am I clear? Okay, am I clear? So today at 12:30 we had a class on law of torts. Okay, and this was only for those who have enrolled for in the course. Those who have not enrolled, they could not see the class. I can understand, friends. Okay, I can understand a lot of people are saying it's in private mode. Kriya Zativ says it's in private mode. Yeah, it's in private mode because it's only meant for people who have enrolled for the course and not a free class. Okay. Up next is the CLAT YouTube schedule. These will be free classes, of course, where we are going to have classes in CLAT YouTube channel. Okay. CLAT YouTube channel of Gradeup. Okay, so in case you require any support, please feel free to dial the number 96500 Okay, am I clear, friends? So do like the session, do like this class, do share this class with your friends, with others who are also preparing for CLAT and other law entrance examination. Okay, so with this we come to the end of today's class. Thank you very, very much. Thank you very, very much. Do enroll yourself. The classes in the master course or in the crash course has already started. Please enroll yourself. Thank you very, very much. God bless you. Thank you from Gradeup.